Hello, my name is Fabian Degen. I'm the owner of FMD Wealth Advisors. This is my podcast, Don't Screw Up Divorce. I'm a certified financial planner, chartered financial analyst, enrolled agent with the IRS, certified divorce financial analyst, and certified Quattro specialist. I help people that are going through major life transitions like divorce. I'm supporting my clients before, during, and after the divorce, and I work with clients nationwide. If you would like my help, click the link in the show notes or visit fmdwealth.com to schedule a call with me. We are open for business. Before we get started, one important disclaimer: we are not attorneys and we do not provide legal advice. Anything that is being said should not be considered legal advice by any means. Please consult with your attorney with regard to your legal questions. So, this week, we're going to talk about the following: order of protection violated in New York, how enforcement actually works, 2 ways to enforce an order of protection. So if you have been granted an order of protection, you already know the order is only as good as your ability to enforce it. New York gives you 2 practical routes, and they are not mutually exclusive. Many people use both. The first is to call the police. If the person the order is against violates one or more of its terms, reporting that violation can lead to their immediate arrest. This is the fastest response when you feel unsafe in the moment, because it puts a criminal enforcement mechanism to work right away. The second is to file an enforcement petition in family court. An enforcement petition formally accuses the respondent of violating your order. Once it is filed, the court schedules a trial to decide whether the violation actually occurred. So, at a violation trial, you, the petitioner, carry the burden of proving the violation, and the standard of proof you must meet rises with the consequences being looked for. This is one of the most misunderstood parts of the process. In an ordinary family court matter, the court must be convinced it is more likely than not that the violation happened. Where criminal-like consequences such as probation or a fine are on the table, the stricter standard of clear and convincing evidence, sometimes called reasonable certainty, applies. The proof, in this case, must make it substantially more probable than not that the violation occurred. If the court is considering jailing the respondent, the proof must rise all the way to the criminal standard of beyond reasonable doubt. So when the proof is sufficient, the consequences can be significant. An offender can be jailed for up to 6 months for each separate proven violation. A petitioner who proves several distinct violations could, in theory, see the court impose a 6-month term for each of them. So a common question in that case is, how soon will there be a hearing? Hearings are usually held within 2 to 4 months. The exact timing depends on the court's backlog, the attorney's calendar, and any pretrial motion practice. Either side can file a pretrial motion. So, for example, a discovery request or a motion to dismiss. These motions can delay the proceeding or, in the case of a successful dismissal, end the matter before any trial. If there is a genuine basis to dismiss a petition for failing to state a cause of action, that is worth pursuing with your attorney, because it may prevent the need for a trial altogether. So let's talk about if someone can be removed from the home first. Yes, in family offense cases, especially where the allegation involves violence, a person can be removed from the home before the case is even heard. The court wants to ensure the violence does not recur, and it has the power to enforce a stay-away order that effectively results in that removal. If the removed person generally has nowhere else to go, their remedy is to act quickly. File an order to show cause before the same judge, asking to modify the order so they can return to the residence if there is a sound basis to do so. They should not simply move back in and risk arrest. So let's talk about how a violation trial looks like. A trial involves both sides testifying and presenting witnesses and other relevant evidence. Because domestic violence often happens with no third party present, the parties themselves are frequently the only witnesses. After each party testifies, on direct examination, the other side attorney may cross-examine to challenge that account. Beyond eyewitnesses, common witnesses include experts in the field of domestic violence and anyone who saw or heard relevant evidence about either party. Documentary evidence often includes photographs, emails, text, social media posts, and audit or video recordings. So preparation is everything. Decide with your attorney well in advance which witnesses and exhibits you will present and prepare intensively for both your own direct testimony and the cross-examination you can expect to face. The more organized your evidence, the easier it is for the court to find that a violation occurred. So let's talk about the penalties a judge can order. If the respondent is found to have violated the order, the court has a wide menu of penalties. This includes modifying or extending the original order of protection, placing the respondents on probation, anger management, or drug or alcohol rehabilitation, directing payments of the victim's counsel fees, requiring medical insurance coverage and reimbursing of medical costs caused by the incident, ordering interim custody and child support, and incarceration of up to 6 months for each separate proven incident. So several of these penalties carry real financial weight. Medical reimbursement, counsel fees, and interim support all involve money changing hands. It is worth coordinating with your certified divorce financial analyst so that anything that the court orders is actually tracked, collected, and reflected in your post-divorce budget rather than simply existing on paper. An order that is never enforced provides no protection and no recovery. So, why does it pay to have a counsel, even on enforcement? So some people hesitate to involve an attorney in an enforcement matter because of the costs. But enforcement is essentially and precisely the context where the math often favors hiring a counsel. When you are the one enforcing an order, the judge may direct the other side to pay the fees your attorney would otherwise charge you. In other words, the cost of competent representation can be shifted to the party who broke the order. That makes retaining an experienced family law attorney far less expensive than it first appears, and considerably more likely to produce the outcome you need. So how can you prepare for the hearing? Because so many family offense violation cases come down to the party's own accounts, preparation often decides the outcome. Well before your court date, work through with your attorney exactly which witnesses you will call and which exhibits, photographs, emails, texts, social media posts, or video you will offer to prove each violation. It is also helpful to understand the rhythm of a trial. Each side testifies on direct examination and is then cross-examined. Beyond the parties themselves, witnesses can include experts in the field of domestic violence and anyone who saw or heard relevant events. Knowing what cross-examination feels like in advance makes you a steadier, more credible witness on the stand. So, if you have never seen a family offense proceeding, it is worth reviewing educational materials on how these hearings actually unfold. So the courtroom is not unfamiliar territory when your case is finally called on. So let's talk about enforcing an order of protection. Enforcing an order of protection does not happen in a vacuum. Among the penalties a judge can impose on a proven violation are interim custody and temporary child support, which means a single enforcement proceeding can begin to reshape both your parenting schedule and your household finances. Family violence can also serve as a material change of circumstances supporting a later custody or visitation modification. It is usually not by itself a basis to change an existing child or spousal support order, though in some situations, such as when assault leaves someone unable to work, it can be one factor among many in a broader support case. Because these threats connect, it makes sense to treat enforcement, custody, and support as one interrelated picture rather than separate problems. This is where working with a certified divorce financial analyst alongside your attorney pays off. An advisor can model how interim custody and support, medical reimbursement, and counsel fees awards flow through your cash flow and budget, and can make sure that any money the court orders is actually tracked and collected. An order you win on paper protects you only if someone is watching that it's honored, and that follow-through is as much a financial planning task as a legal one. Let's focus on some frequently asked questions. First one, should I call the police or file an enforcement petition? So you can do either or both. Calling the police is the right move when you feel unsafe right now, because reporting a violation can lead to an immediate arrest. An enforcement petition is the route for having a court formally find a violation and impose penalties. The two tracks work well together, and using one does not prevent you from using the other. Next question, how many times can the other person be jailed for violation? Well, a judge can impose up to 6 months of jail for each separate violation that is proven to be required standard. If you prove multiple violations, the court can, in theory, sentence the respondents for each one, which is exactly why documenting every incident carefully with dates and details is so important. Next question. Do I need a lawyer to enforce an order of protection? Well, you're not strictly required to have one, but enforcement involves shifting burden of proof, evidence, rules, and potential penalties that are easy to mishandle alone. Keep in mind that when you're enforcing an order, the judge may order the other party to pay your counsel fees, which often makes hiring competent counsel the more economical choice. This was this week's podcast, Don't Screw Up Divorce. My name is Fabian Degen. I'm the owner of FMD Wealth Advisors. I'm a certified financial planner, chartered financial analyst, enrolled agent with the IRS, certified divorce financial analyst, and certified Quattro specialist. I help people that are going through major life transitions like divorce. I'm supporting my clients before, during, and after the divorce, and I work with clients nationwide. If you would like my help, click the link in the show notes or visit fmdwealth.com to schedule a call with me. We are open for business.